Hey folks, it's Mark Smith here at the Four Boxes Diner. I'm going to play for you in just a moment my speech I gave to the Second Amendment Foundation at the Gun Rights Policy Conference out there in San Diego, California. Had a great time talking with many of you. Enjoyed signing books, talking to Adam Kraut and Alan Gottlieb of the Second Amendment Foundation. And of course, our friend Jared over at Guns and Gadgets. Had a nice time speaking with him about the future of the Second Amendment and what's going to happen in November in the elections. So without further ado, here's my speech. Make sure you like this video and subscribe if you are not already a subscriber. And we'll see you again very soon. But let me know what you think of the speech that I gave just this past weekend. We'll talk to you soon. Major breaking news. I'm just kidding. All right, we got a lot to cover in the next 30 minutes. I hope you're ready to take some good notes, a lot to discuss. Before we get to the details of what I'm going to talk about, I want to let everyone know yet again, what is the Four Boxes Diner? The Four Boxes Diner is named after the four boxes of American liberty. The cartridge box, which refers to the guns. The soap box, which refers to the First Amendment. The ballot box, which refers to the right to vote. And of course, the jury box, which refers to the right to jury trial as well as the rule of law. This was made popular in the 19th century by abolitionist Frederick Douglass, who talked about you cannot be a citizen if you do not have the three boxes, he had three boxes then, of American liberty. You cannot be a citizen, and one of the critical, essential characteristics of being a citizen and not a serf or a slave was the right to bear arms. Now, the diner references casual conversation and not a lecture, but people always ask me, what is the Four Boxes Diner? And that's where it comes from. So today, to get down to substance, there's three things I want to cover. First of all, we're going to talk about the current constellation of the Second Amendment and understanding how the Rahimi decision from earlier this year fits into that constellation of Second Amendment cases, and overall, the Rahimi case was very good for us. We'll talk about that. Then I want to talk briefly about the absurdity, the craziness, the inconsistency of this sort of ridiculous Joe Biden-Kamala Harris ghost gun rule that's being challenged in an oral argument before the U.S. Supreme Court on October 8th. We're going to talk about that. You're going to be shocked with some of the things that we've uncovered there. And then we're going to talk about how we interplay, the interplay between Second Amendment arguments and arguments arising from the Loper-Bright case in the Supreme Court's administrative law, regulatory law precedents. We're going to do it in the context of suppressors to see how they all work together to vindicate our right to keep and bear arms. It'll be very detailed and geeky, so I know you Four Boxes Diner fans will really like that quite a bit. So before I get there, though, there's one critical lesson. If you can only remember one thing from my discussion today, it's I want you to know about someone who, if he were alive, would have received an award from Alan today at the luncheon. And it's an important figure that has largely been lost and should not be lost because he's extremely helpful to the Second Amendment movement, and we can use him in many respects. Because remember, a reason why we should be proud to be Second Amendment supporters and advocates in this great country is because we not only have the law on our side with the Second Amendment itself, we also have the history and public policy. All these arguments, if you're intellectually honest in my view, all work in favor of the right to keep and bear arms. Now, I want to take us back to the year of our Lord, 1764. 1764. Like, why are we going back there, Mark? Well, I'll tell you why. Because there's a man I want to introduce you to, Cesare Beccaria. For anybody who talks to the media, who writes articles, that does scholarship, that does law review, talks in the media, whatever it is, you need to know Cesare Beccaria. He's extremely helpful. Cesare Beccaria was an Italian criminologist who wrote in the Enlightenment era, who was so influential when he wrote a book called On Crimes and Punishment, that both Thomas Jefferson and John Adams literally wrote about this man and his thinking as they were negotiating and dealing with the creation of our country and, of course, the Constitution. And why do I say this, and why is this so important for you to know this? Is because some of the most powerful languages in support of the Second Amendment came from this Italian Enlightenment philosopher and criminologist who's largely been lost to history, although I'm trying to bring him back. The first thing he writes about is that just because something can be misused, or just because something can give rise to injury or damage, does not serve as a basis to ban it. Sound familiar? This is what he wrote in the year of our Lord, 1764. This is not an NRA slogan from the 21st century. This is 1764 with a man who was so influential to the founders that his book was available for the people that drafted the Constitution as part of their little library they put together. This is what he writes in 1764, Cesare Beccaria. False is the idea of utility that sacrifices 1,000 real advantages for one imaginary or trifling inconvenience. Listen carefully. That would take fire from men because it burns. Water would be banned because you may drown in water. Thus, that has no remedy for evils except destruction. He goes on to say that the laws that forbid the carrying of arms are laws of such a nature. That's literally his language from 1764. He points out that they disarm those only who are neither inclined nor determined to commit crimes. Again, gun bans ban guns from the law-abiding and not from actual criminals. 1764, that idea was articulated by the man that was highly influential in the creation of our Second Amendment. And he goes on to say, as a matter of public policy, in 1764, hundreds of years ago, right? Before sloganeering from the NRA or whatever they want to say, he goes on to say that gun bans only hurt the law-abiding. Here's what he writes. Gun ban laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than to prevent homicides. For an unarmed man may be attacked with greater confidence than an armed man. Cesare Beccaria, 1764. It's very important that you know him. He's very influential. So whenever the anti-gunners like to say things like, this is made up by this radical court or this and that, you have a historical baseline from which to argue intellectually and whatnot about where the founders were coming from. So with that said, let's turn to the 21st century and let's talk about the 5 most important Second Amendment cases you need to know about, the 5 Supreme Court cases that make up today's constellation of Second Amendment jurisprudence. We're going to run through them quickly and then I'm going to explain to you how to understand the recent Rahimi case within that constellation. We all know that in 2008, the Heller decision came out. It basically stood for 3 propositions. The first is that the Second Amendment indeed protects an individual fundamental right that's on par with the right to life and the right to liberty. It also says that you cannot ban a category of arms that are in common use by Americans for lawful purposes. And it goes on to say that you cannot interest balance away, the government cannot interest balance away your rights in the name of some state interest or government interest or public policy benefit. That was Heller in 2008. In 2010, in the MacDonald case, of course, they took that basic propositions of law from Heller and applied it against the states and localities to say it was a fundamental right. They used the phrase fundamental right, something on the order of magnitude of 14 to 15 times in the MacDonald case, proving that the Supreme Court really, really, really meant it. Then in 2016, for our friends out there in knife rights, this 2016 Caetano case, they made it clear that the word arms, as in the right of the people to keep and bear arms, does not just include firearms. It includes other kinds of arms. Anything that can be used offensively or defensively is an arm. Specifically, they talk about stun guns being a protected arm under the Second Amendment in Caetano 2016. And then, of course, and now we're going to get to a critical teaching moment. Okay, I'm not going to name names here, folks. 2022 Bruen. Now, Bruen does 2 critical things. The most obvious one is they say that the right to bear arms means the right to carry guns in public for self-defense. Fine. Great. That's a no-brainer. The right to keep means to possess. The right to bear means to carry. Okay. Here is the next thing they do, and this is important to understand this distinction. Do not mess this up because the anti-gunners want you to mess this up, but you're not going to mess this up because you will be the smartest person in the room because I will make you such. Bruen was not groundbreaking. Do not say that Bruen was groundbreaking. Bad idea. Bruen was not groundbreaking at all. All Bruen did is it took the Heller methodology of text first, history second, and wrote it out in a paint-by-number approach so that the lower courts that had been ignoring the law from 2008 to 2022 would no longer mess it up. It was not groundbreaking. Heller was reaffirmed. In fact, if you read the Bruen case carefully, it reaffirms and speaks positively about the Heller precedent, and this is very important to our rights. We'll get to that in a minute. It speaks positively and reaffirms Heller somewhere on the order of magnitude of 70 times, okay? So don't ever say Bruen is groundbreaking. We're going to talk about why in just 1 second. It's very important. It's simply a reaffirmation and a spanking of the lower courts that refused to read the Heller decision correctly. That's all Bruen did. It was very important, yes, but it really was not groundbreaking. So with that said, let's turn to Rahimi. Now, Rahimi was decided. This was a catastrophic loss for the anti-gun movement in America. It was a catastrophic loss for Merrick Garland, Kamala Harris, and Joe Biden. And you're saying to me, I don't understand, didn't Mr. Rahimi lose? Yes, he did. But remember, when you look at a court case, there's two critical things that you generally want to look for. One is who won the case. That can be very important, yes. But there's something more important for the Second Amendment movement than who wins the case. It's how the person won or lost the case. The methodology, the interpretation, the approaches, that is what really matters to us, because whatever the Supreme Court says as to how you win or lose a case, the methodology, the way to interpret what the words mean, is something that we in this room will all have to live with for years, if not decades to come. So the methodology and the approach. Now the reason why this is important is Mr. Rahimi, it's true, lost the case because his record was absolutely terrible. You all know that. His record was terrible. 5 related shootings, including a gunfight associated with a credit card being declined at a fast food restaurant, taking his girlfriend's head and hit it into the dashboard, and when a witness saw it, he shot at the witness. Not a good... Now, why is this a terrible situation, what happened? Because Merrick Garland, if you may recall, rushed this case to the Supreme Court. He refused to grant any kind of real extensions to the public defender's office that represented Mr. Rahimi. He sped up everything to make sure that the very next Second Amendment case before the U.S. Supreme Court was the Rahimi case, because it was such a terrible set of facts with a terrible scumbag guy based on the record, and he thought this was his chance to destroy the Heller-Bruen methodology because bad fake facts make bad law. And they utterly failed. And this is the critical takeaway from Rahimi, which is Rahimi, rather than saying we're going to run away and not do it, it reaffirmed Heller and Bruen. It says, no, this is how you do it going forward, and this is how we apply it to the Rahimi facts, which gives rise to what Rahimi is really about and why it's so good for us. For those of you familiar with the scientific method, there's someone known as Thomas Kuhn, and he's the guy that talks about how the scientific revolution works, and it's a good metaphor for what Rahimi means. Thomas Kuhn wrote that you have the scientific revolution, they figure out how you do the scientific method, you propose the hypothesis, and then you test it out, this thing. Once you establish the methodology of doing the science, everything that comes after that is a routine application of the scientific method. Heller, MacDonald, Bruen, and Caetano was essentially the scientific revolution, if you will, the gestalt of those cases with the scientific revolution, if you will, of Second Amendment jurisprudence in America. Everything that follows those cases, those 4 cases, is nothing more than a routine application of the existing scientific method. All you're dealing with now, from Rahimi to the quote-unquote assault weapon bans, propaganda term, the age cases involving 18, 19, and 20-year-olds, the licensing issues, these are nothing more than a routine application of existing law. In other words, and this is why it's so powerful for us, you've now moved the Second Amendment from a groundbreaking set of massive changes, if you will, metaphorically, into the world of just routine application of law. No different than every year we get First Amendment cases, every year we get Fourth Amendment cases, every year we get Fifth Amendment cases, every year we get First Amendment cases, now every year we're going to get Second Amendment cases. It's going to just be part of the normal routine application of the groundbreaking law that we got, starting from Heller through, of course, Bruen, if you want to put those things kind of together, okay? So that's why this is so good. The Second Amendment has finally moved to a world where it's in the ordinary course of just handling Second Amendment cases like any other constitutional right, and that normalization and mechanization, if you will, of this law is very good for us because it makes it much more difficult to the point where you can't get rid of it. Even the liberals on the court kind of acknowledge that this is the way that text first, burden shifting to the government to do historical tradition analysis, that is the methodology going forward. And the attempt to destroy it with the Rahimi case utterly failed. That's why Rahimi ultimately is a big win for us. And that's how to think about it. Okay, Vanderstock. Vanderstock is going to be argued on October 8th. I think somebody's going to be doing a presentation, so I won't belabor the point beyond to say that this is the case involving this is the ghost gun case, which is, of course, a political propaganda term for what? Well, these are just privately made guns, or these are unserialized guns. And what the Biden administration did, of course, is they used an executive order to try to say, we're going to expand the definition of what a frame or receiver is so that we're not just going to ban essentially frames and receivers, regulate frames and receivers. We're now going to regulate things that can become frames or receivers. Now, I'm going to tell you what they did, and I'm going to tell you the absurdity of the argument. What they did is this, and this is how to think about the Vanderstock case. It's a complicated case, but I'm going to make it really easy for you right here, right now. Up until this new rule of the Biden-Harris administration, the way the ATF dealt with these frames or receivers or partial frames or receivers or whatever you want to call them, the weapons parts kits, was as following. They looked at the object and they said, what is this today? What has been done in the past through the moment in time I'm looking at this to figure out whether or not that is a frame or receiver under the definition of firearm in the gun control act, right? They looked at the past up to the moment and said, what is this object? The sleight of hand that has now taken place with Harris and Biden and this new rule is, instead of saying what happened in the past, backward looking through today, they've now changed it. And now they ask, what can this become looking into the future? Oh yeah, this little kid playing on the playground could theoretically become Tom Brady, right? He could become the president. He could become this, he could become that. So you see what they've done? They went from looking at the frame or receiver, the alleged frame or receiver, and backwards to what it could become. And now they're saying, well, if you do this and you make this and use a screwdriver and you use a Dremel tool and you this, right, then it could become a frame or receiver. Now that's hooey. Now to prove that it's hooey, I'm going to give you two quick examples, and that's this. Number one, tell me if you think this sounds a little internally inconsistent. And they submitted this, mind you, to the United States Supreme Court. Now, you can say what you want about the Supreme Court, but I can assure you they're not dumb. They're some of the smartest people on the planet. We can disagree with them, but they're not dumb. The ATF's position in Vanderstock is literally this. They're saying, oh my God, a few years ago we realized there's this extremely dangerous thing called ghost guns. Ooh, and it's so dangerous. Now we're seeing these ghost guns. They're very dangerous. Gangbangers are using it. Oh my God, it's a new crisis. We have to do something. Okay, fine. So what did they do? And they literally argue this in their briefs. You know what they say they do? So we've decided to do what we've always done in response to the new crisis. That's literally what they're saying. They said, in response to a new problem, we're simply doing what we've always done, which makes no sense. This is what they write in their brief to the U.S. Supreme Court. The final rule responds to that new public safety crisis by reiterating and clarifying ATF's long-standing view that the plain text of the Gun Control Act does not permit such ready evasion. So of course that's entirely makes no sense. You have a new phenomenon and you solve it by doing the same old thing. Now they're saying this, of course, is because they're trying to persuade the Supreme Court that they did not do a 180-degree turn on how they interpret what a frame or receiver is, which of course they did. And to make matters even worse, and I forgot this was on Thursday or Friday, the Solicitor General's office representing Harris and Biden just submitted an extremely embarrassing letter to the Supreme Court admitting that they made a terrible mistake, that something they said in their brief is factually wrong about how they interpret something and how they dealt with one of the weapons parts kits. Extremely embarrassing because the Solicitor General's office is supposed to be sort of the best lawyers in the country, and the fact that they wrote a letter to the U.S. Supreme Court apologizing for making a mistake in their brief is quite embarrassing, and that just happened. And I suspect the Harris-Biden ATF is going to get destroyed in this case of Vanderstock, and that's going to be some of the reasons why. Okay. Now, am I going too fast? Now I want to talk about the interplay. We've talked about the Second Amendment. We've talked about ATF, Loper-Bright, administrative rules, regulatory precedents, okay? Now we're going to blend them together with an example so you can see how all this works. And I thought about which one to use, and after hearing the suppressor discussion, I thought, you know what, let's use the suppressor as an example because I think that's a pretty good one here. It teaches a lot about how to interpret the Second Amendment and deal with regulatory problems as well as Second Amendment clear problems. Okay, so let's understand. As a reminder, of course, suppressors are not firearms in and themselves, and they go on firearms and they function. And we're going to talk about why that's somewhat important here. Just as a reminder, we know that the Supreme Court in Heller and Bruen says that an arm is anything that can be used offensively or defensively. So the question becomes is how does a suppressor which attaches to a firearm become an arm under the text of the Second Amendment? The right of the people to keep and bear arms shall not be infringed. How does it become an arm? Okay, a couple different ways. I'm going to do the most obvious way one, and then I'm going to do a second way in a moment. Obviously, a suppressor, when you put it on a firearm, improves the operation of the gun because it makes it safer for the users and the people surrounding the people that are using it because it prevents hearing loss and the like. Now, is there any Supreme Court precedent that we can use to show that suppressors are indeed arms as defined by Supreme Court Second Amendment jurisprudence? Oh, yes, there is. Mark Smith found one. In the Bruen case, this is what they write when they're talking about what is an arm. It says, quote, even though the Second Amendment's definition of arms is fixed according to the historical understanding, that general definition covers, ready, modern instruments that facilitate armed self-defense. Can we agree that suppressors help facilitate armed self-defense by making it safer for the user and making it safer for the people in the home around the user? Obviously, the answer is yes. There's no real dispute that that helps facilitate. And if you don't believe Mark Smith and you don't believe Bruen, why don't we just ask Congress, those intellectual giants in Congress, what do they think? And I'm happy to report that under the federal gun control laws, they define silencers, suppressors as firearms. So, it's going to be very hard for the federal government to say they're not firearms when they literally call them firearms in the federal statute. Okay, now, critical other teaching point here is concomitant rights. This is important. People talk about ancillary rights. When you talk about the right to a trigger, the right to a barrel, the right to a scope, the right to a suppressor as an arm, I want you to use the following word going forward. Okay, I don't want you to be sloppy. Can't be sloppy in the Four Boxes Diner. I want you to refer to these things that are not expressly not an express firearm as concomitant rights. The reason why I want you to use this is because this is the word that Justice Gorsuch, Justice Thomas, and Justice Alito use when they talk about rights that are implied within a constitutional right. And, the right to a suppressor, to the extent it's implied in any respect, is a concomitant right, and that's what the Supreme Court calls it, so you should use the same language as the Supreme Court. Now, how does this apply? I've got 8 minutes, and we're making pretty good time here. So how does this set of materials involving the Second Amendment I went over, and now the definition of suppressors being an arm under the text of the Second Amendment, how does all this work, and how do we win? I think it's actually suppressors a relatively easy case, and I'm going to make it much easier, pretty easy for you. There are 3 types of suppressor laws in America. 3 types, and I'm going to go over all 3, and when you come out of here, you will be able to argue before the Supreme Court why they're all unconstitutional, okay? 3 types of laws that are problematic for suppressors. Number 1, you have states like Illinois that ban them. Ban the possession of suppressors. We'll get to that. Number 2, you have NFA issues associated with their taxes. You have to pay a stamp tax to get a suppressor, a targeted tax on a suppressor. Okay, we'll talk about that. And of course, you have the gun registration, right? You have a registration of guns associated with, hey, Mark owns the suppressor, and now there's a list of a registry of guns, a registry of Mark on the list. Now you have a registry, and is that constitutional? Well, I think you're going to know what the answer is when we're done with this. Let's start with the first one. Can you ban suppressors under the Second Amendment? The answer is obviously no, because once they're arms, as meaning arms in the right of the people to keep and bear arms, and guess what happens? 2 things happens, obviously. Now, if you ban them, you've implicated the right of the people to keep and bear arms, and now the burden shifts to the government. And remember, this is key, the burden shifts to the government. When the burden shifts to the government, they have to show a historical tradition of some firearms regulation. But here's the key. Remember when I told everyone, don't ever, ever, ever say that Bruen is groundbreaking? Why did I tell you that? Why did I say that? The anti-gunners are desperate to make everyone in America, including the judges, forget the existence of Heller. Why? Because Heller already did the text-first historical analysis of the historical tradition of firearms regulation. and concluded the only conceivable basis that a firearm could be banned or an arm could be banned in American life at all is an arm that's dangerous and unusual, whatever that means. And the Supreme Court says, whatever that means, here's the one thing we know for certain. If an arm is in common use by Americans for lawful purposes, it cannot be banned. Maybe there's other ways to stop a gun ban, but the one way for certain is this. There's almost 4 million suppressors in the United States. It's in common use. It cannot be banned once it's an arm. And the reason why don't call Bruen groundbreaking is because they want you to pretend that Heller is not the law of the land, because Heller creates the in common use test, which is extremely good for us. And here's the other key thing to understand about the in common use test that people screw up. Who bears the burden of proof of showing in common use? The government. Why is that? Because the in common use test arises from the historical tradition, which means the burden is shifted. Text first, implicated, burden shifts to the government. The burden shifts to the government to show the historical tradition. And because the in common use test is part of the historical tradition of firearms regulation, guess what? The government bears the burden to show that AR-15s, that suppressors, that arms are not in common use. They cannot possibly do this, which is why the anti-gunners want you to say that Bruen is the groundbreaking new rule, skipping over the fact that Heller was the same sort of methodology, but they want you to pretend it doesn't exist. And that's why I don't see how suppressors can be banned. And let me add one additional argument. This applies for magazines, and I'm going to make a note here. This applies to large capacity magazines and suppressors. Keep in mind that when you ban suppressors or you ban magazines, it is a firearms ban. Repeat after me. You don't have to repeat after me. So, if you ban suppressors or you ban magazines, okay, it is a firearms ban. In addition to everything I just said, in addition to that, it's a firearms ban. Why? Think about it. Think about it for a moment. If you ban a suppressor or a magazine, what have you done? You have banned an entire category of firearms. Talk about magazines first. If you ban magazines that hold more than 10 rounds, you have banned all firearms in that jurisdiction that are capable of firing more than 10 rounds without having to be manually reloaded. That is a ban on an entire classification of firearms. Likewise, suppressors. If you ban suppressors in Illinois, you have banned an entire category of firearms, i.e. firearms that are capable of being fired with suppressed fire. You see how banning these parts, if you will, constitutes a firearms ban, even if you don't want to talk about the concomitant kind of approaches that is black letter constitutional law. So always remember those two things, because the anti-gunners play games with here. It gets a little confusing, a little geeky, but now you know, and now you can win in the Supreme Court better than a lot of lawyers that are on the anti-gun side. Okay, so that's how you deal with bans. I got 3 minutes. We're now going to go over taxes, and we're going to do regulations, and we're going to get this done. Taxes. Only 2 things you need to know. Whenever you hear about a targeted tax, whether it be an ammo tax or a gun tax or an insurance requirement, it is a tax, a targeted tax. Only 2 things you need to know to show. And again, with the suppressors, you got to pay money to the right, to the ATF, all that to get your tax stamp for the NFA item. That's a targeted tax. Under the Minneapolis Star case in 1984, Supreme Court precedent, a targeted tax on ink, unconstitutional. Under Harper versus Board of Elections in the 1960s, a targeted tax in the form of a poll tax of $1.50, unconstitutional. You cite the Harper versus Board of Elections. You cite the Minneapolis Star. Both Supreme Court precedents, it says a targeted tax on a constitutional right is verboten. Once a suppressor is viewed as an arm that's in common use, it's already a protected arm, you tax it in a targeted way, it's unconstitutional targeted tax. Under those 2 very clear Supreme Court precedents, game over for a tax on suppressors. Registration, okay. I'm not going to get into inside anything other than to say this, that it was very important for Brett Kavanaugh to get on the Supreme Court that he wrote that dissent in Heller 2 in 2011. Not only did he in that Heller 2 decision say that AR-15s and the ban of DC of these semi-automatic weapons, that they were unconstitutional, he said something else has been often getting lost, and that is this. Brett Kavanaugh, as a judge on the D.C. circuit in 2011 in the Heller 2 case, also said that gun registries are unconstitutional. This is what he writes. In any event, this is Kavanaugh in 2011, mind you. In any event, the proper test to apply is Heller's, not Bruen, Heller's history and tradition-based test. Because most of the nation has never required, and even now does not require, registration of all lawfully possessed firearms, DC's strict registration law is not longstanding in the United States. After Heller, not Bruen, after Heller, some licensing requirements remain permissible, and he's talking about commercial issues, which is not relevant to this, but he goes on to say, DC's registration law violates the Second Amendment as construed by the Supreme Court in Heller. So the registration of your suppressor with the federal government is going to be unconstitutional for the reasons articulated by Kavanaugh and Heller too, and I can assure you he's not the only person that thinks that on the U.S. Supreme Court. I've got 30 seconds. I'm just going to say two quick things. One of the things to understand, when I talk on my channel, I do make fun of a lot of anti-gun judges. It's true. But there's another problem. I'm going to call it the patent law problem, and I'll make this quick. The reality on the ground in many of these federal courts is this. The problem we really have is the patent law problem, and what I mean by that is the judges rarely see Second Amendment cases. These are not like contract cases or tort cases. These are cases they rarely see. If they see guns in the courtroom, it's usually like a criminal case not involving the Second Amendment. So therefore, when they first encounter the Second Amendment law, they're learning it for the first time, and when you learn anything from the first time, you're prone to make mistakes, and the anti-gun movement with their briefing often takes advantage of the fact that the judges are unfamiliar with this area of law because it doesn't come up a lot in their courtrooms. That's the first problem. The second problem is the gun technology problem. I've talked to many elite lawyers, and that's the world I travel in, elite lawyers and elite judges, even those that are originalists and supportive of the Second Amendment and all that, and they will tell you they've never fired a firearm. They don't know anything about firearms. It's not that they hate firearms. It's like they went to Princeton, they went to NYU Law School, where I went to, right? They go to Columbia, they go to Harvard, Yale, and they just don't encounter guns. And even if so when you start talking about guns with them, they have and a reason why I call it the patent law problem is because a patent case, judges rarely see patent cases, so they don't know what patent law is, so they got to figure out patent law, and then they got to figure out the fight between, let's say, the electrical sockets. Why is one different than the other? And they don't understand the technology either. So again, that is the problem we face in many of these courts. Even if they're trying to get it right, they don't understand the Second Amendment law as well as they should because it's new to them, and they don't understand gun technology, and they can be easily duped as a consequence of that. And that's why the work that you guys do in trying to educate the public and whatnot is so important, because the public includes federal judges. And I will just quote Benjamin Franklin and wrap up with this, because I think this speaks to everyone in the Second Amendment. After the signing of the Declaration of Independence, Benjamin Franklin turned and said to his peers the following: "We must all hang together, or we most assuredly will hang separately." And I want to remind everyone that in the Second Amendment movement, that holds true in my view. That if we don't work together all the way across the board to fight for our rights, not just the Second Amendment rights, but all of our Constitution and all of our rights, then I have a feeling bad things will happen to us and to the rights and to our country that we love and hold so dear. So with that said, I will be signing books out there. They are complimentary, so feel free to stop by, and I appreciate your time, and we'll talk to you all soon.
Thank you, Mark. Orders up. Table 2A.